Good evening, everyone. Welcome to another live streaming of basic transfer pricing. Tonight, our topic will be about the arm's length price of services rendered by seconded employees and also the evaluation of separate and combined transactions. The case that we will discuss is this Marzen Artistic Aluminum Limited versus Her Majesty the Queen. This is a case, a transfer pricing case in Canada. I would like to say thank you po sa ating mga subscribers. Umabot na po tayo ng 1,210 subscribers as of tonight, August 23, 2021. Shout out, Tare.
Wala pa pong shoutout. May viewers ako na apat.
Okay, so shout out po sa ating mga viewers. Thank you very much po, and we'll continue with our discussion. What is this arm's length price of services rendered by seconded employees? For the seconded employees, the seconded employees are employees of different or another corporation, which in this case are related party companies or associated companies, and they have an employees seconded or assigned in the other company, related company, and the services rendered by these employees are paid by the employee at a cost plus 10% markup. So the question here is the payment of the seconded employees arm's length having the agreement is to pay for a cost plus 10% markup. And also, the issue here is what would be the transfer pricing method that is going to be used. Is it the transactional net margin method or the comparable and controlled price method when it comes to the determination of the services, no, the payment of the services by these seconded employees. And the court here found out that it should not be transactional net margin method as alleged by the Marzen, in this case, by the company, but it should be comparable and controlled price method. For me, I also opted for the comparable and controlled price method. Why? Because this is payment for the services rendered. And when we say payment for services rendered, then another law that we're going to satisfy in this case is that of the labor law. No? Kasi mga seconded employees to, and our labor is regulated by the Department of Labor in our case, halimbawa in the Philippines. No? So I opted for the use of the comparable and controlled price method. Why? Because you are going to compare how much is the prevailing payment for that particular services in the area. And there you are. Since the wages are regulated, then that is the best benchmark. No? You can have your payment for the services higher but not lower than what is being regulated. Another issue here is the evaluation of separate and combined transactions, because in this case, there are separate companies, no? Associated companies that are manufacturing their goods, and this other employees who are assigning employees or have seconded employees in another company are the ones also buying for the product of the company where their employees are seconded. So the court here requires that the separate and combined transaction should be evaluated in order to determine if the payment are arm's length. No? So let's now go to the case of Marzen Artistic Aluminum Limited versus Her Majesty the Queen. a Canadian case. No? Let's see the background of the case. But for your information, the decision in this case is in favor of the government or Her Majesty the Queen. No? Talo dito ang Marzen Artistic Aluminum. Okay? But we want to find out what are the issues in this case and how the parties presented their evidence in court and how the court decide, no? In this case, in favor of the government or the tax authority. Okay. Okay, so in this case, the Minister of National Revenue reassessed Marzen. Minister of National Revenue is the tax authority in Canada. No? Reassessed Marzen Artistic Aluminum Limited. Reassessed meaning adjusted, assessed, no? For additional tax. The appellant in respect of fees paid to its wholly owned Barbados-based subsidiary, Starline International, Inc., during taxation years 2000 and 2001. So the years involved in this case are 2000 and 2001. The minister took the position that the appellant, who was not dealing at arm's length, had paid an amount greater than the amount a person dealing at arm's length would have paid to SII. SII is the Starline International, Inc., which is a related company of Marzen. For sales, marketing, and support services in the United States under a marketing and sales services agreement or MSSA. The minister applied paragraph 247 2A and C of the Income Tax Act of 1985, the Act, and made transfer pricing adjustment in respect of the deduction the appellant took for fees paid to SII or the related company. So in reason cited as 2014 TCC 194, Sheridan J., which is the judge of this in this case, of the Tax Court of Canada, disallowed the appeals of reassessment made by the minister in respect of the appellant's 2000 and 2001 taxation years, except for a minor adjustment of 32,500 in each of those years to the amount that SII paid to Starline Windows, Inc. or SWI. This is an appeal from that decision. So in this case, nag-appeal. So sino nag-appeal dito? Si Marzen Artistic Aluminum, no? Okay, siya yung appellant. And then yung government dito is the respondent, no? So this is an appeal from that decision. Background. The appellant Marzen Artistic Aluminum Limited was in the business of manufacturing and selling windows products in Canada. Starline Windows, Inc. No? So si Marzen are manufacturing windows, no, in Canada. Starline Windows, Inc., a sister company, was located in the United States and had been involved in an unsuccessful attempt to penetrate the U.S. residential window market in the state of Washington in 1998. Remember, the case involved here is 1999 and 2000. No? Longview Associated Limited, or Longview, is a Barbados-based corporation wholly owned by Mr. David Somrick, a resident of Barbados. Mr. Somrick is in the business of establishing international business corporation in Barbados and providing management and support services to these corporations through Longview. Okay. So in 1999, after meeting with Mr. Martini, the majority shareholder of the appellant, ito yung Marzen, no? Mr. Somrick incorporated SII in Barbados. What is SII? This is Starline International Inc. in Barbados with the appellant as its sole shareholder. So Mr. Martini is the sole shareholder of Starline International Inc. based in Barbados. Mr. Somrick became the managing director of SII. So Mr. Somrick becomes the managing director or manages the SII. The appellant, Starline Window Inc. and Starline International Inc. were involved in a business structure aimed at successfully penetrating the U.S. market for window products manufactured by appellant or Marzen. SII provided marketing services and support for the appellant Windows products in the United States. SWI, or this Starline Windows Inc., seconded its employees. So this is one of the issues, aside from the payment of the management fees, the other issue here is that the secondment of the employees. No? So SWI seconded its employees to SII on a cost plus 10% basis. So the question here is this cost plus 10% is arm's length. No? And it purchased the window products directly from the appellant at the same price they were sold in the United States. Imagine how much did this SII purchase? Same also with the price that it sold the product in the United States. So there is no markup. So in computing its income for 2000 and 2001, the appellant deducted fees paid to the wholly owned Barbados subsidiary, which is SII, in the amounts of Canadian dollar 4,168,551 and 7,837,082 respectively. So in the first year of this SII in Barbados, there is already a management fee paid by Marzen in the amount of 4,168,551 in 1999 and 7,837,082 in 2001. No? Correction. For the year 2000, 4,168,551, not 1999. No? So the MSA, or the Marketing and Sales Services Agreement, under which SII provided marketing and sales support services to the appellant in the United States, called for the payment of a fee equal to the greater of US dollar 100,000 or 25% of sales. So they have to there are two bases for the payment of this marketing fees or support services. Greater, whichever is higher, between $100,000 or the 25% of sales, no? Originated by SII. No, this is very high, yung 25% of sales. The MSSA also stipulated that the appellant had to provide working capital to SII, okay, when needed. The MSSA was amended in August 2000 to provide for the payment of bonus to SII to 10% on all confirmed sales in California, provided SII made net sales greater than $10 million between August 1, 2000 and December 31, 2001. So there are amendments to the Marketing and Sales Service Agreement to provide for incentives, no, to SII. The appellant paid $2.1 million bonus to SII under the amended MSSA. So Mr. Somrick, the managing director, did not share the bonus paid to SII. Si Mr. Somrick is the author, no? He is the one registering businesses in Barbados, no? And also acted as managing director of SII, a Barbados-based company. No? So in this case, Marzen Corporation paid $2.1 million bonus to SII, no, under the amended MSSA, or the Marketing and Sales Service Agreement. SII and SWI were also parties to a Personnel Secondment Agreement, no, or PSA, and an Administrative and Support Services Agreement. So, meron ng Personnel Service Agreement, meron pang Administrative and Support Services Agreement. Ang dami. Under the latter, SWI seconded its employees to SII who marketed the appellant's window products in the United States and elsewhere. Secretarial and administrative support services were equally provided to SII. The PSA called for the payment by SII to SWI of the actual cost of the seconded personnel plus a 10% markup. No? So actual cost, meaning how much is the payment for the services or salaries of those personnel. SII paid SWI 2.1 million and 2.8 million in 2000 and 2001 under these agreements. Okay. So that is the payment for the agreement. SII paid Longview US $30,000 in 2000 and 2001 for the management and administrative services, and $2,500 for services provided by Mr. Somrick as its managing director. No? Mr. Somrick is the managing director of SII. SII declared dividend in 2000 and 2001 of Canadian dollars 2,011,500 and 5,299,620 payable to the appellant, who included these amounts in its income for Canadian taxation purposes. So, SII is already declaring dividend. Huh? So, these dividends were then deducted from the appellant's taxable income pursuant to Section 113 of the Act on the basis that they were paid out of SII exempt surplus. So, SII, a company based in Barbados, is already gaining income and hence declaring dividend, because the dividend is the payment to its stockholders. And in this case, who is the lone stockholder of SII? It is Mr. Martini, and Mr. Martini also owns the Marzen and the SWI. No? So the minister imposed transfer pricing adjustment pursuant to paragraph 247(2)(a) and (c) of the Act. The minister limited the appellant's fees paid to SII in 2000 and 2001 to respectively Canadian $2.1 million and Canadian $2.8 million. The minister also imposed a transfer pricing penalty of Canadian $500 to $1,519 under subsection 247(3) of the Act for the taxation year 2001 only. So, the tax authority in Canada imposed penalties, no, for the appellant or Marzen. The appellant appealed the reassessment and the levy of the penalty to the Tax Court of Canada. No? Okay. So what is the statutory framework for the transfer pricing? No? The following provisions are relevant in this case. Income Tax Act 1985. Transfer pricing adjustment. So this is the law in Canada about transfer pricing. No? Income Tax Act of 1985. So transfer pricing adjustment under Article or Section 247(2), where a taxpayer or a partnership, a non-resident person with whom the taxpayer or the partnership or a member of the partnership does not deal at arm's length or a partnership of which the non-resident person is a member are participants in a transaction or a series of transactions. No? Participants siya sa transaction o marami pang transactions. Letter A, the term or conditions made or imposed in respect of the transaction or series between any of the participants in the transaction or services or series differ from those that would have been made between persons dealing at arm's length. Or letter C, where only paragraph 247(2)(a) applies, the terms and conditions made or imposed in respect of the transaction or series between the participants in the transaction or series had been those that would have been made between persons dealing in arm's length. Or penalty 247(3), a taxpayer other than a taxpayer, all of whose taxable income for the year is exempt from tax under Part 1, is liable to a penalty for a taxation year equal to 10% of the amount determined under paragraph 247(3)(a) in respect of the taxpayer for the year. Where 147(1), the court may determine the amount of the cost of all parties involved in any proceeding, the allocation of those costs, and the persons required to pay them. Number 2, costs may be awarded to or against the Crown. So these are the reasons. In exercising its discretionary power to subsection 1, the court may consider A, the result of the proceeding, B, the amount in issue, C, importance of the issues, D, any offer of settlement made in writing, E, the volume of work, F, complexity of the issues, G, the conduct of any party list tended to shorten or to lengthen unnecessarily the duration of the proceeding. H, the denial or the neglect or refusal of any party to admit anything that should have been admitted. I, whether any stage in the proceeding was improper, vexatious, or unnecessary, or taken through negligence, mistake, or excessive caution. Whether the expense required to have an expert witness give evidence was justified, given the nature of the proceeding, its public significance, and any need to clarify the law. The number, complexity, or technical nature of the issues in dispute, or the amount in dispute, and any other matter relevant to the question of cost. Okay. So those is the relevant regulations when it comes to transfer pricing. Since 1939, the Act has included provisions under which a Canadian taxpayer may be reassessed to include in his Canadian income the difference between the price paid for property or service to a non-resident with whom he does not deal at arm's length and the price he would have paid had he be dealing at arm's length. Section 247(2) of the Act is the successor provision to Section 69(2), which was repealed in 1998. A multinational enterprise is free to set a price for a transaction between corporations it controls under different tax jurisdictions. Transfer pricing is the setting of the price between related corporations. Identifying the fair market value of transaction between related corporations is the underlying principle of transfer pricing. It entails a comparative exercise with what parties dealing at arm's length would have considered. The language in Section 247 does not contain criteria, nor does it specify a methodology to determine the reasonable amount parties dealing at arm's length would have paid in any given transactions where transfer pricing principle apply. Consequently, Canadian courts have relied on the OECD guidelines, 1995 the guidelines, as being of assistance in that respect. No? The Supreme Court stated in Canada versus GlaxoSmithKline Inc., this is the very famous case, At paragraph 20 and 21 that the guidelines are not controlling as if they were a Canadian statute, but they are useful in determining the amount a reasonable business person who was party to the transaction would have paid if it had been dealing at arm's length. The court also affirmed that a transfer pricing analysis is inherently fact-driven. No? So when you make a transfer pricing analysis, it should be factual, no? Meaning all that data that you analyze or you use should be factual, no? Real. Since the guidelines were considered by the judge in her analysis, a copy of the permanent extracts has been appended to this decision for ease of reference. No? So let's now go to the decision of the court. No? In the tax court, may shout out, Hari? Sige, shout out muna.
Shout out po kay Jim Carlo Bautista.
Okay, good evening.
Siya lang po, ma'am.
Sige, shout out sa iyo, Jim Carlo Bautista. And thank you for watching. No? Now let's come to the decision of the court. No? So we have identified the issues there, yung payment ng management fee, and also yung seconded employee, no? And the management fees. No? So what is the decision of the tax court? So in the tax court, the main issue before the judge was whether the terms and conditions of the MSSA between the appellant and SII differed from the terms and conditions parties dealing at arm's length would have agreed to, and whether the minister was correct in making the adjustment to the actual fees and bonus paid by the appellant to SII. In sum, the judge had to determine whether the transfer pricing provisions found in paragraphs 2472A and C of the Act and the penalty imposed pursuant to subsection 2473 were applicable in this instance. No? So the judge allowed the appeal in part. She found that an arm's length party would have paid an amount to Starline International Inc. that exceeded the fees paid by Starline International Inc. to Starline Windows Inc., but only in the amount of $32,500 on each of 2000 and 2001. No? Okay, so yun ang sabi ng judge. The judge identified the transaction under review as the MSSA between the appellant and SII. While acknowledging that the guideline did not have force of law, the judge indicated they could assess the court in determining what business people dealing at arm's length would have paid. No? Okay. On the first issue before her, which was whether the terms and conditions imposed in respect of the MSSA between the parties differed from what would have been agreed to by parties dealing at arm's length. So the judge concluded that SII was essentially an empty shell with no personnel, no assets, and no risk. No? Kasi sino to si SII? This is the company na pinaregister lang sa Barbados with the help of Mr. Somrick. No? So, sa bagong terminology po ng transfer pricing, this transaction has no substance. No? So the judge concluded that SII was essentially an empty shell with no personnel, no assets, and no risk. Imagine these comparability factors that are very important, no? The functions, the assets, and the risk, no? And in this case, applied to SII, then the court has an opinion that SII was essentially an empty shell with no personnel, no assets, and no risk. No? Nakabox lang na company. No? So the judge, on the basis of the testimonial evidence that was adduced before her, rejected the appellant's position that Mr. Somrick, SII Managing Director, made a significant contribution on behalf of SII in developing the marketing strategy or in managing and supervising SWI's operations. The judge concluded that the arrangement between the parties did not reflect dealings at arm's length. Oh? So Mr. Somrick's advice to shift to the California high rice market for window products was given in a personal capacity, and it followed that there was no need for the appellant to compensate SII for the advice, no? Kasi unang-una wala namang employee yung SII, no? So the judge then turned to the second issue and proceeded to determine what an arm's length party would have paid for these services. Her first determination was to the effect that such an analysis is comparative. Therefore, she needed to identify the proper transaction and the review and then consider all of the relevant factors a party dealing at arm's length would have considered, and then to compare it with a proxy transaction that truly reflected the circumstances of the appellant's transaction. So it is in that context that the judge rejected the expert report submitted by the appellant. The judge found the report to be fundamentally flawed for the following reasons. First, the report assumed that SII and SWI operated as an amalgam. Ano yung amalgam? United or as one. Under the direction of Mr. Somrick when providing services to the appellant. Notwithstanding the fact that SII and SWI were separate entities, that assumption was contrary to the guidelines. Secondly, the appellant admitted that SII and SWI were separate entities. No? They are separate entities, although they are associates. No? Thirdly, the PSA stated that it was not meant to create a partnership or joint venture between SWI and SII. No? So, amalgam meaning united or they are one. No? So the judge rejected the expert applications of the transactional net margin transfer pricing method, and the judge also dismissed several of the factual assumptions contained in the appellant's expert report regarding Mr. Somrick's activities in SII and SWI based on the oral evidence adduced at trial. No? So yung mga evidence nila is conducted orally. With respect to the determination of the arm's length price, the judge relied again primarily on the guidelines, which identified the comparable and controlled price method as appropriate. No? So nandito na yung recommendation na dapat comparable and controlled price method and not yung cost plus method. No? She determined that the transactions between the appellant and SII was one where SII contracted to supply services. SII bought the services under separate contracts with SWI, Mr. Somrick, and Longview. The judge also found that SII used the fees it received to pay those who provided the services. It followed that there were three components to the marketing fee. The judge determined that the cap method was more consistent with the guideline since it respected the legal relationships between the entities involved and kept SWI and SII as separate legal entities, which they were in fact. She also determined that SII acted as a flow-through entity. No? Parang conduit lang sila. No? Okay. Wala na shout out, Ari? Okay. So the judge accepted the minister's assumption that the fee paid by SII to this SWI under the PSA was an arm's length amount. No? Consequently, she focused her inquiry on the two other components. She found that Mr. Somrick dealt with SII at arm's length and that the fee of US dollar $32,500 paid to Mr. Somrick and Longview by SII was comparable uncontrolled price for the transaction between the appellant and SII under the MSSA. So this finding led the judge to conclude that an arm's length party would have paid an amount of SII that exceeded the fees paid by SII to SWI, but only in the amount of $32,500 in each of 2000 and 2001. Okay. The judge then went on to examine whether the appellant had made reasonable effort to determine and use an arm's length transfer prices for the purposes of the act and ruled it had not done so. She allowed costs to the respondent despite the fact that the appellant was partially successful in the appeal before her. No? Okay, so the appeal issues. The appeal raises the following issues. No? There are three. Whether the judge erred in determining the terms and conditions imposed in respect of the MSSA between the appellant and SII differed from what would have been agreed to by parties dealing at arm's length. Okay, so number two, whether the judge erred in finding that an arm's length party would not have paid SII any fees in excess of the amounts allowed by the minister, plus $32,500 had they been dealing at arm's length. Whether the judge erred in declining to award cost to the appellant, no? Hindi nila pina-award yung cost. Okay. So these are the issues that should be resolved in the appeal, no? So as this appeal is from a decision of the tax court, the appellant must establish an error of law or palpable and overriding error on a question of fact. Okay, so the appellant's position. In a memorandum of fact and law, the appellant raised 8 different points in issue. In my opinion, this can best addressed in the 3 issues identified by the respondent, which have been reproduced above. At the hearing before the court, the appellant raised the following arguments. No? So during the hearing, yan yung that I like most in cases. Kasi if you really read the cases along, not on the digest, no, you will know the deliberation, how the parties presented their evidence in court, and then how the court evaluate and make a decisions out of those evidence presented. No? So in this case, at the hearing before the court, the appellant raised the following agreements. No? The appellants, after a review of the case law on transfer pricing adjustment, and more particularly the principle outlined by the Supreme Court decision in Glaxo, underlined that the judge erred by failing to determine an arm's length price for the services rendered by the seconded U.S. employees. So ito na yung lumabas sa appeal, yung arm's length price for the services rendered by seconded U.S. employees, which was not determined during the previous deliberation of the case. The appellant approached the issues before the court from the perspective that the judge should not have confined her analysis to its separate transactions and entity. According to the appellant, the judge failed to consider the value of the service package received by the appellant from SII, which would have included the efforts of Mr. Somrick and the efforts of the seconded U.S. employees. SWI whose skill had been largely upgraded in order to sell windows successfully in the high-rise California market. So the appellant takes issue with the judge's approach, which in fact considered 3 separate transactions. So counsel for the appellant pointed to the fact that the minister had failed to adjust the contract prices between SII and SWI on the basis that the only amount SII paid to SWI under the PSA and the ASA agreements was an arm's length amount, no? So yun yung sabi ng counsel ng appellant. The counsel then directed the court to paragraph 136 of the judge's decision where she states that it is not an issue that SWI provided sales and marketing staff to SII at an arm's length price. According to the appellant, this is a fundamental error if the judge had applied the principles outlined by the Supreme Court in Glaxo. She would have considered Mr. McDonald's expert report, who took the position that the minister should have valued the seconded U.S. employees. Okay. Skilled efforts. Counsel for the appellant also underlined the significant increase in the appellant's gross margin over the period as evidence of the value provided by SII to the appellant through the efforts of the seconded U.S. employees. So, yan po yung nangyari dito, no? The appellant also disputed the three bases provided by the judge for rejecting the expert report presented by Mr. McDonald. In the appellant's view, Mr. McDonald was correct to treat SWI and SII as an amalgam, no? United sila, no? Under which Somrick's decision when providing services to the appellant despite the fact that they were separate entities. The report concluded that the services provided by both SII and SWI, when considered together, justify the position that the fees paid were in keeping with the arm's length principle. The appellant contends that the judge could not rely on the respondent rebuttal report prepared by Mr. Rogerson, or register and rebuttal report, to counter the appellant's expert report, nor could she rely on it as a direct evidence of Mr. Rogerson's opinion on the ultimate issue. Okay. So the appellant also challenged the judge's reliance on the guidelines to justify her choice of the cap method, no? So from transactional net margin method, ginawa nilang comparable uncontrolled price method, no? Sa TNMM, what are you going to compare? The net margin. In comparable uncontrolled price method, what are you going to compare? The price, no? So, in the appellant's view, the guidelines are more flexible on the choice of methodology, and the judge should have considered the transactional net margin transfer pricing method proposed in the appellant's expert report. So finally, the appellant argues that the judge erred in her award of cost to the respondent because it was partly successful before the tax court and because the minister failed to tender an expert report that met the basic requirements for admission in evidence. At the onset of the hearing before the court, counsel for the respondent remarked that the appellant is now bringing forward a different theory of the case than it did before the judge. In counsel's view, having failed to adduce convincing evidence that Mr. Somrick was instrumental in implementing and actually overseeing the marketing strategy, the appellant is now arguing its case on the basis that the judge erred in undervaluing the amounts paid by SII to SWI. The respondent points out that at trial, the appellant never disputed the minister's assumption that SWI provided sales and marketing staff and services to SII at arm's length price, nor did the appellant adduce any evidence with a view of establishing a different value for these services. So, maganda yung argument dito ng unang judge, no? Na yung appellant dito, si Marzen, hindi naman siya nag-take ng effort, no? To value the amount of services or the price of the services paid for the secondment of employees. parang pinabayaan lang, no? The appellant did not, no, adduce evidence, no, for establishing a different value for these services. So according to the respondent, the judge properly applied the teachings in Glaxo, no, because that famous case in Glaxo sa Canada yung nangyari, no. She adhered to the principle outlined in that decision that applying the arm's length principle is a comparative exercise. Why comparative exercise? Because you really have to compare, no? Because you cannot establish an independent price without comparing it with the related parties' prices. The judge was correct, therefore, to consider the independent interest of each party to each of the transactions and these respective roles and functions. The respondent takes the position that the judge applied Section 247 of the Act correctly and that her analysis addressed the appropriate transaction, the MSSA agreement. In the respondent's view, the judge addressed the correct issue, that is whether the terms and conditions between the appellant SII, Mr. Somrick, Longview, and the amount of marketing fees paid to SII differed from what a party dealing at arm's length would have paid, no? So yun na yung contention. The respondent contends that the judge was correct to rely on the guidelines and to consider the entities involved as separate, as in this case, no? The PSA agreement specified that the agreements did not intend to create a joint venture or partnership between SII and SWI. The respondent also points to the fact that the appellant acknowledged that SWI and SII were separate entities and operating as such. The respondent disputes the appellant's position that the judge focused on the wrong amount and that she erred in concluding that the quantum of fees paid by SII to SWI was not an issue as it was on arm's length basis. Accordingly to the respondent, the judge had to accept the assumption as true because it was not disputed by the appellant, no? So in the respondent's view, the judge could accept the arm's length transaction between SII and Mr. Somrick Longview as a comparable and controlled transaction which could reliably serve as an internal comparable under the CAP method. According to the respondents, the judge could conclude that Mr. Somrick dealt with SII at arm's length and that the fee of US $32,500 paid to Mr. Somrick and Longview by SII was comparable and controlled price for the transaction between the appellant and SII because it was based on the evidence that was presented before her. Finally, on the issue of cost, the respondent takes the position that cost allocation are discretionary and should not be disturbed, no? So what is the analysis? The court in Canada, General Electric Capital Canada, Inc., at paragraph 55 indicated that the statutory objective underlying paragraph 2472A and C of the Act is to prepare the avoidance of tax resulting from price distortions, which can also in the context of non-arm's length relationship by reason of the community of interest shared by the related parties. So the Act calls for the elimination of all the distortions that arise in any given transaction between related parties. Okay. So the Supreme Court has provided further guidance in Glaxo, paragraph 61 to 63, when it referred to the guidelines which specify that that transfer pricing is not an exact science, no? So in the exact science, transfer pricing, it just requires a lot of common sense. The Supreme Court noted that because comparators will rarely to identical in all market services and consequently, the tax court judge must allow some leeway in establishing satisfactory arm's length price. The court in that case equally cautioned that the judge needed to consider the role and function of each of the entities that are partner to the transactions, no? So finally, the court underlined that when determining prices between parties dealing at arm's length, the interest of each party to the transaction should be considered. No? So the guideline assists at the court in its task of ascertaining the price that would have been paid by parties dealing at arm's length in the same circumstances. They identify and describe a number of pricing methods that can be applied to identify the arm's length price for a given transaction. So in the present appeal, the issue is fundamentally whether the judge erred in her application of the principle outlined in paragraphs 247, 2 and C of the Act, and more precisely whether the judge identified the proper transactions and took into account the appropriate related party contract price. No? Okay. So I find that it was open to the judge based on the evidence before her to identify the transactions under review in the MSSA between SII and the appellant. At any transfer pricing analysis is fact-driven, no? So factual talaga ang transfer pricing analysis. The appellant needed to point to an error the judge made in the assessment of the facts leading to that determination. The appellant argued that its expert report did not dispute that the transaction under review was the MSSA, but indicated that the value of the services provided to SII by SWI through the seconded U.S. employees should also have been taken into consideration. So, why taken into consideration? Because it has to be deducted also sa taxable income. No? So, the judge's finding was based on the guidelines. I find no error in her part in that regard, more so as I reviewed the evidence that was before her. It is undeniable that the appellant never challenged the minister's assumption that the quantum of fees paid by SII to SWI were not in issue in the appeal before her. Having reviewed the record and the notice of appeal filed before the tax court, I cannot find any evidence that was adduced by the appellant in the tax court to challenge the minister's assumption that the price for the seconded U.S. employees set on cost plus 10% basis was not an arm's length price. No? As a taxpayer, the appellant had indeed the initial onus to demolish the minister's assumptions in the assessment. No? So the judge rejected the appellant expert report, which proposed to treat SII and SWI as an operating as a single entity under the direction of Mr. Sombrick. She provided 3 reasons for doing. No? Okay. So the judge acknowledged that the arm's length principle necessarily entailed separating SII and SWI roles in looking at the underlying agreements, more precisely Article 4.1 of the PSA. The agreements clearly spelled out the intent of the parties not to create a partnership or a joint venture between them. The judge also found that the appellant's expert report rested on an incorrect factual basis, since, as acknowledged by the appellant, SWI and SII were separate legal entities and operated as such. No? Okay. So, in this case, the court decision here is in favor of the tax authority, which is the Minister of Internal Revenue, no, in this case, no? Okay. So why is it that the cap method is should be used instead of the transactional net margin method, no? Why? Because as we study, yung mga previous studies natin, so under the cap method or the comparable uncontrolled price method, of course, we we are going to compare the price, no? And in this case, since what is going to be compared here is the payment for the services of those seconded employees, then it can be determined. And also, for the comparables, it is easy for the company to find a comparable because this payment to services are regulated by labor, no? Or by the government. Okay. So the third issue, the granting of cost to the respondent, it is well-established principle that orders granting cost are discretionary and command deference. No? So Rule 147 of the Tax Court of Canada rules specifies the factors that a judge must consider in awarding cost. An appellate court should only intervene if the judge considered irrelevant factors, failed to consider relevant factors, or reached an unreasonable conclusion. No? So in the present case, no valid reason to intervene. So for these reasons, I propose that the appeal be dismissed with cost. No? So yung appeal dismiss, siyempre may question, kanino siya in favor. Of course, sa mananalo, which is the queen or the tax authority in this case. No? So, meron pa silang mga appendix dito on the transfer pricing guidelines, which in our previous videos, meron na po tayo dyan on the transfer pricing guidelines, no? Na mga discussions natin, 2017 transfer pricing guidelines yan, which are the latest. Although, for the transfer pricing guidelines on financial transactions, we have yung 2020. And of course, for the profit split, ang dami din mga bago about the profit split when it comes to in relation to the 2017 transfer pricing guidelines of the OECD. You know? Okay. And also, what are affected also, new requirements for documentation. No? So, walang questionary.
Shout out po ma'am kay Sir Eugene.
Okay. So, shout out Sir Eugene Cruz, no? Okay, so with that, I would like to say thank you very much and let's call it a night.